shame, my lord, of what has transpired for the last 1 week for 10 days, my lord. I would bring to your lordship's notice two aspects of this matter regarding Archie Kaur, my lord. One is, my lord, day before lordship is aware, there was a football match that was supposed to be held yesterday between Mohun Bagan and East Bengal. That's a big derby of Kolkata football, my lord. On 17th evening, All India Football Federation, which is a private body, of course, receives information from the authority, police authority, that adequate securities cannot be provided. So the match got cancelled. It was not rescheduled. The match got cancelled. The tournament was transferred to Jamshedpur. That is a separate question altogether. Points were divided. Now, I'm not on that, Millard. Yesterday, when the day before, when the match got cancelled, Millard, the supporters of both the clubs decided that they will go there, assemble, and they will chant justice for Raji Kormalan. Peaceful. More than 85,000 spectators who were supporters from both the clubs and also Mohammedan Sporting Club also joined in, Malad. They were there, Malad. They were stopped 2 kilometers before the stadium, Malad. Lathi charge was there, Malad. More than hundreds were arrested. Apparently, on a phone call that was intercepted by the police, which was never been made public. That interception says that there will be acid bulbs and petrol flares that will be thrown at the stadium, so on and so forth. And unfortunately, Millard, till today morning, Millard, yesterday there was a press briefing by the Commissioner of Police, Bidhannagar Commissionerate, saying that we are taking steps, etc. But till now, in the morning, before I'm mentioning this matter, before this bench, Millard, there is no notification which is prescribed under 163(2), Millard. If I to accept that there is a notification that has to be, Millard, given, that has to be given ex parte under subsection 2 of the new act, Millard, there is nothing published on the website, nothing circulated to any of the major media houses. Only a press briefing was done after the incident happened, my lord. So I would like your lordships to take suo moto cognizance of the matter. If your lordship wants us to make an application, my lord, I would, being a life member of Mohun Bagan Club, my lord, I would like to move this in person, my lord, whenever your lordship allows me, my lord.
What is the relief you?
My lord, the relief I am seeking is, my lord, are twofold, my lord. There's another notification I would like to club this. That's the notification of Calcutta Police, my lord, the police commissioner, my lord, on 17th itself, my lord, withholding and restraining rallies, processions, etc., my lord, because the entire country, my lord, now is in favor of the victim who has been brutally raped, murdered, my lord, and the police. The matter is, this bench is in session of the matter. The CBI is investigating at this juncture, my lord. This is what the cops of Kolkata, who has lost, they do not have any semblance of shame left in them, my lord. If I may, Lordship will kindly excuse my expression, my lord. This is what is happening, my lord. Today, my lord, this is the second prayer, my lord. I will make it a composite application if your lordship wants, my lord. These two, my lord, there is a provision under 163(5) to make an application so that the executive magistrate has the power to rescind, change, or alter the decision, my lord. There were attempts to make application because this is a new act and a lot of people did not know the provisions, my lord. They approached and they were shooed away virtually. This is how they are treating this whole thing, my lord. Women have been beaten up, my lord. But it's absolute anarchy, my lord. If I say so, my lord, it is an absolute anarchy, my lord. I feel ashamed being a part of the system, my lord. I'm an officer of the court, my lord. We have to deal with legal matters every day, my lord. We also at times accept brief for the accused. People who practices in the criminal side do accept brief for the accused, my lord. But this cannot go on, my lord. Lordship has taken a cognizance of the matter. Matter has been referred to the CBI, my lord. But police has to act judiciously. Raj Dharma is the whole purpose of the police now, my lord. As it stands, my lord, today, the whole country, starting from everybody, even in Times Square, my lord, they have held protest, my lord. In Atlanta, they have held protest, my lord. It is all over the internet, social media. Everybody is seeing, my lord, what is happening, my lord. And this is how the police acts.
All right, we'll grant you leave to file the petition.
Grateful, my lord. And one more thing, my lord. This is not related to the matter, my lord. Today, my lord, we, the lawyers of Calcutta High Court, my lord, without any, my lord, color, banner, flag, anything, my lord. Our only color would be this black and white coat that we are wearing. We worship this for the last 25 years. I mean, 25 years in this profession, my lord. There are many of our brothers or sisters are here, my lord. All senior members, my lord. We will be holding a peaceful rally starting from gate B at 110, my lord. And this area, this precinct will be, my lord, rallied, my lord, around Assembly House and Akash Bani, my lord. We are aware that there's a 163 also prevailing in this area because this is an administrative block. We have information that police may intercept us. If it happens, my lord, we'll take recourse to whatever legal recourse we have, my lord. But if the rally continues, my lord, we may, my lord, some of the members, because once the rally breaks out, my lord, we intend to attend the court and the judicial functioning, my lord, from 2 o'clock. If it is slightly late, because we cannot give a formal thing, because none of the bars are officially involved. The lawyers who are informed and the members of the bar, everybody is a member of the bar, and the general body has also decided on this, my lord.
If there is a prohibitory order, then are you not
I do not know if there is a prohibitory order over here, my lord. There is no prohibitory order officially here. Normally, they do not allow rallies in front of the Vidhan Sabha, but we hold rallies, my lord, because when I am aware, my lord, we take the rallies from, my lord, Red Cross Place and this surrounding area, my lord. We may get slightly late, my lord. If your lordship, my lord, takes this into account and inform the learned judges, my lord, honorable judges, my lord, that if some of our members, my lord, get slightly late, my lord, to come and attend the courts, my lord.
The court can resemble at 2:30.
Or the court can can an information be given out, my lord, from your lordship's office, my lord, if the court reassembles post lunch at 2:15, my lord.
30 to 30, make 2:15. Seniors are there.
Seniors will come now. 2:15, my lord. This is all I want, my lord.
This is only our.
So if suppose something is placed in writing, I'll be able to.
I understand, my lord, but you see, my lord, the bar officially is us, but not officially with us, technically speaking, because bar, lordship is.
You can speak to the secretary bar.
We have already, and he has moral support. The other members of the bar also has moral support. It is beyond politics now, my lord. It is about humanity, my lord. It is about the conscience, my lord. I cannot look at the eye of my wife, my lord, for the last 10 days, my lord. My head hangs in shame, my lord. Because it's always a saying, my lord, not all men, but it is always a man. That's the saddest part of this whole fiasco that has happened, my lord.
But we live with my senior, my lord. We are ensuring that we rejoin at 2. But they are, because the small precincts we are just marching is a silent, that will be a silent march, my lord. All seniors will be there. So it's a small rally. But my lord, if we are 5-10 minutes
No, if Mr. Dalapati gives a letter on the administrative side, I can do something.
my lord, this is not a bar, is not taking this
Everybody
resolution.
would have assembled in court now.
My lord, this
we will see what we can do, my lord. We'll see. And lordship, I will be moving it in person, my lord. I will be preparing and moving it.
We'll grant leave.
Grateful, my lord.
My lord, deeply obliged.
My lord,
Seek leave.
I am appear in person. My fundamental right violated by the Calcutta High Court, as the case has been filed by Honorable Supreme Court advice letter against the Honorable Chief Justice of Calcutta High Court, and till date case number not given me, filing number given me, in the matter of violation of Honorable Supreme Court judgment by Calcutta High Court judges, and in the matter of 1946 Foreigner Act violated, and in the matter of Article 235 as per advice by Honorable Supreme Court. And court official told me, go to Honorable Chief Justice Secretary or OSD. My lord, it is my fundamental right. You and I, both Indian citizen, law equal for every citizen.
Rightly so. Please give the letter, you give the letter.
Lordship, may I seek
mention, my lord, this matter, my lord.
This matter is a exploitation of the workers. The workers who are engaged in the Sialda Karshed for mechanized cleaning of the coaches and they are the sub-grade workers. But prison is lying under the public interest litigation. Our last order was on February. Thereafter, you will also directed to serve all the respondents. They are already served. Matter is on the 1st August, item number 1110. My only prayer is that agreement is going to be expired, my lord, sooner than later. My relief will be then, it will
To
be.
the letter, we'll try to
My lord,
update.
I have
See,
analyzed-
my son,
Uh,
who
kindly,
is
my
a,
lord, let it be upgraded, my
football
lord.
supporter, he was willing to go for the yesterday's protest when the match got cancelled. As my learning senior mentioned recently, has been picked up by Shantragachi police station yesterday afternoon. Since then, no whereabouts is given by the police where he is. Equally, Lordship, there are others, many others who have been picked up the police. Police are intercepting the mobiles, WhatsApp group messages, and they're picking up the people. So this is one of those incidents, Lordship. Kindly give me leave to move it at
Can be done.
2
Is
p.m.,
there
Lordship.
anybody from the state? Yes, you are for in the state panel. Can you bring the ground pleader or Mr. Amitesh Banerjee? You please wait.
Lordship.
Lordship, I'm tendering unconditional apology, my lord, that I'm mentioning this matter again. My lord, your lordship on Friday heard the matter and passed an order regarding article case. My lordship, I'm not blaming anyone, my lord. My matter still is not tagged, my lord, and my name is not appearing in the order, my lord. I'm beseeching before your lordship, let my matter be tagged, my lord.
Actually,
Your
we
lo-
have listed the matters on Wednesday.
Lordship,
Probably on that day, we can correct the order and
lordship,
include
only
that.
beseeching if my matter can
Your
be tagged.
lordship, this matter pertains to Arjikar incident, lordship, the heinous. I beg lordship that kindly bring up the matter on Wednesday at least, so that it can be heard.
Give the letter, give the letter.
I already sent the letter to OSD. I bow down.
Yes, doctor.
My lord, I'm here related to Arjikar, but I was here Friday. Your lordship was kind enough to grant me leave to file, but urgent hearing because the hospitals are shut down, poor patients are dying. All I want to stop that strike. I am in total support for justice, but not at the expense of the poor patient. And it's clear violation of Supreme Court. Dr. Strike, we went there. So, my lord, I have served the opposite party. Kindly keep it tomorrow for hearing, my lord, under to be mentioned.
Give the number. We will decide when it.
Yes, my lord, because they will die. So kindly hear me tomorrow.
Kindly grant leave to file a memorandum of agreement without the certified copy.
Leave grant. Yes.
With your lordship's leave, may I mention my application for inclusion? All the respondents are already served. Lordship, this matter was due to appear today, but it is not listed yet.
And I mentioned
Grateful.
application. Speaking of the matter, only I was saying, the council will be outside, may date be fixed, next week, anytime next week.
So you indicate the date in the letter. Have you given the date?
26, next month.
All right.
As per direction of my lord's order dated 28/8/2023, after the judgment of the Supreme Court, that 8th July judgment, I mentioned this matter. My lord asked me to mention this matter. I mentioned this matter, but it was not appeared in the list.
You just give the number. Let us see.
It is.
Your lordship, I'm mentioning this matter
I
before
have
your,
also supplied the judgment of the Supreme Court also.
your lordship, I'm mentioning the matter due to some exigency. This is my mother. She has filed two CAN applications, one for restoration and one for delay condonation.
Hmm.
She is an old widow, 75 years of age and suffering from various ailments. Now the matter is that the case is presently lying under court number 26.
Hmm.
And the case was dismissed for default due to the professional negligence of the advocate. If your lordship kindly enter into the matter, you will realize the fact. But what is happening?
But the CAN application has to be heard by court number 26.
Yes, but their lords.
Can you not mention in court?
Yes, the matter came before their lordship on last 16th August.
Hmm.
But their lordship is not are not willing to hear the matter from us because he is.
Court 26 is division bench is civil.
Just a moment, your lordship. Their lordship are not willing to hear the matter because she has appointed me as her agent.
Different, sir. On the administrative side, suppose I have to do something, unless the bench releases the matter, I cannot pull it out. you make a mention for early hearing. Then if any order is passed by the bench, or if the bench releases the matter, then I can.
Your Lordship, yesterday, their Lordship became very angry with me. They warned me that if I say anything more, they will put me in jail. But their Lordship is not willing to willing to obey the validity of such authorization, because I have the Supreme Court ruling in this regard. Your Lordship may kindly look it out. I have one copy. For that I am seeking pardon. Your Lordship may kindly find point number 14, where it has been mentioned that the authorized agent may conduct the hearing. I am also an advocate, and Justice Devanshu Bosak is insisting me to take legal aid, but she has no faith on legal aid, and also the state aid. She is not getting her pension salary from last 2003. And there is a very unprecedented situation with her going on. She is living with unfed.
Unless it is released on the administrative side, I will not be able to do anything.
Your Lordship, kindly guide me. What shall I do? Will I approach him to release?
If you can make a mention before the bench saying that we mentioned before the court number 1. Court number 1 has directed you to mention before the court number 26, and whatever orders are passed, you then based on that you give a letter.
This is my humble submission, Your Lordship.
letter to
Kindly assign the matter before your bench. After releasing.
Lordship, seek permission to mention before your Lordship, appeal against the single bench that they passed an order that I was arrested without a 41 notice. And all case were under 7 years punishment. After the order was, the case was filed under 226, the single action bench, Justice Amrita Sinha, has passed an order warning the IO but not taking any action against her to doing so. And the case was disposed dated 10 July. Moment the case was disposed, Lordship, police under CRPC 149 has the power to call. They are calling me and harassing me day in and day out. At least 7 times I was called in and sit in the police station. The prayer in the writ petition was that I was arrested without a 41 notice, and as per the Anish Kumar guidelines of the Honorable Supreme Court, that they are to be pursuing a proceeding against the investigating officer. But it was not done. She was let off with a warning. And moment this case was disposed, I'm being harassed right now, Lordship. I've filed a fresh appeal against that in a MAT application.
What is the offense registered in that?
Sections were 387, 509, 506, 354A, C, and D of the IPC. 5 sections are bailable sections and 1 within 7 years imprisonment.
You give the number, we'll list the appeal.
Sure. Thank you, Honorable Lordship.
Yes, Mr. Banerjee, what is your friend is saying his son was picked up?
Means my client's son, Lordship, that he has been picked up yesterday from Santragachi police station, and he's present. His father is present here. Without any thing, Lordship, he wanted to go for the protest, and that's why from afternoon he was picked up.
I'll take instruction. I'll not make an off-the-cuff statement.
That is what we wanted your presence.
If he just gives me a copy, I'll
give that.
Any plain copy, anything would do.
Whatever is.
I'll give the mail. The email he has sent.
You say forward it to Mr. Banerjee.
Because I don't believe in making off-the-cuff statements.
No, you ask them to release them. Yesterday, police initially were.
Let us see for what reason. If you gives me 2 minutes time, I shall come back.
Please verify.
Whenever when would you lot?
12 o'clock.
12 o'clock. I shall be back before Lordship. But exactly what is the situation? And let me take the instructions.
Grateful.
I'll come back.
Yes.
Appellate side, daily list, serial number 1. Lord, I am for the applicant, my lord.
I appear for the straight response.
Lord, in dealing with the matter, lordship kindly takes the trouble to see two orders, my lord, pass. First is 1st May and
Yes,
second.
we remember the matter.
Yes,
And what happened to the affidavit in opposition?
neither affidavit of opposition has been filed, even the deed in question, which my lord directed to surrender before the register. Only two original deeds, the deed in question, which is the issue, the certified copy of which was surrendered. Then my lord said by 27, police will ensure that it is surrendered. Unfortunately, my lord, no step has been taken. I loaded.
My lord, already we have deposited the original deeds that has come to my mobile.
So what is the instruction ground pleader?
Till 27th of July, they did not submit the deed, my lord. Then we have registered the cases against them under section 188. My lord, now my learned friend says, my lord, that he.
27.5 he has deposited it.
My lord,
But no, my lord,
the original deed, there were 3 deeds. They have submitted only 2 deeds. The third deed they have not submitted.
No, ask your client to submit the third deed today. Tomorrow we'll list the matter. You just get a report from the
My lord,
police.
I'll take the report. Come.
This tomorrow. Time is granted to the respondents 12, 13 and 14 to surrender the remaining one title deed
May I pause for a
to the
moment?
police.
Let it be keep it on fast day, lordship.
Why?
No, I have some difficulty tomorrow and day after tomorrow, 2 days, lordship. Only keep it on Thursday.
No, your client let him surrender.
I have to
By today.
Yes.
By 5 p.m. today. Within
My lord, that, your lordship may kindly mention the deed number. It is 2947 of 2010.
Deed number 2947 of 2010. By 5 p.m. today, within bracket 19/8/2024. List the matter under the same caption on Thursday.
2947.
Next.
2947.
Serial number 2 and at item number 2, I am appearing for the appellant.
There's some correction or something.
My lord, I am taking a week's time because, my lord, I have not received the written communication to withdraw the matter, my lord.
Yes, last time
My lord,
somebody represented.
my lord, as it is a PSU, my lord, I have not received. My
The
lord.
learned advocate appearing for the appellant requests a week's time to obtain appropriate written instruction from his client. List next Monday under the same caption.
Grateful, my lord.
Next Tuesday. Tuesday.
Serial number 3 and 4.
Madam, in this matter, I am appealing for the WBS.
I appear for the appellant petitioner, my lord. This matter involves, my lord, the writ petitioner filed the writ petition for electric connection, wherein thereby relying forged document. In the initial stage of the writ petition, we did not appear. Thereafter, order was passed. Subsequently, filed an application for recalling the order and thereby praying for proceeding on the 340 of Indian Penal Code has to be initiated, on the Code of Criminal Procedure to be initiated, since forged document was there. There was a direction for affidavits. In the affidavit, my lord, it was specifically admitted that those documents which we are saying the forged document were proper. They did not deny the contention, in spite of which the 340 proceeding was not initiated, my lord. Since already another proceeding was done by the learned court below, for which the application under 340 was rejected. Challenging, we prefer the appeal before this court, my lord. Now, the difficulty is, my lord, two things, my lord. Affidavit service. Affidavit service.
Order basis আমরা যেন কানেকশনটা দিয়েছি কোন অর্ডার
সেকেন্ড অর্ডার সেকেন্ড
ডেট কতটা ইন টার্মস অফ দ্য অর্ডার ডেট আমরা কবে
এটা না এটা কোনটা এটা সেকেন্ড অ্যাপ্লিকেশন সেকেন্ড ডিটেল
অর্ডার নিতে মানে আমরা যে কানেকশনটা দিয়েছি ঠিক আছে
ছয় জুলাই 2022 6 জুলাই 2022
আমরা কানেকশন দিয়েছি 24/8 6 জুলাই, তাই তো? ডব্লিউপি নাম্বার এটা কি ছিল?
129 1972 তখন ঢুকি। Certificate, enlistment certificate.
Your interest is protected.
Kindly visualize one thing. A person comes with a forged document before this court of law. It's a record.
No, no, no. The court has recorded a finding with regard to that aspect of forgery. Please come. No, no, no. Please come to para 20, page 6 of the impugned order.
আমাকে সাপ্লাই করুন। প্যারা 20 বলছি, প্যারা 20 is 6.
Para 20, then para 22. So the court has only decided whether it will amount to forgery as contemplated under 463. Ultimately said that the court doesn't find it appropriate to direct an inquiry to be conducted or refer the matter under 340 CRPC. However, said that any of the observations will not be a bar or will not operate against your client if any other criminal case has been registered and if an investigation is going.
My only contention before your lordship, my lord, a person comes with two writ petitions, with two times he have produced those forged documents, obtains orders from the court. These are on record, and in the opposition he has not denied those.
See, that is
kindly consider that inquiry has to be done by the police authorities, whether those are.
There are two documents. One is a certificate of enlistment. The other is a leave and license. The court examined those documents because in one thing, the word provisional is there.
The original there was the word provisional and a date was marked that was wiped out. The word provisional and the date was.
Their plea was there was flood, etc. The documents got damaged. So this is a question of fact.
That has to be inquired by the police authorities, my lord.
You lodge a complaint. That is why in the last paragraph, if you please see the last paragraph, 32, that protects your interest.
Those are, my lord, a person who comes twice before the court with unclean hands, my lord. My only contention was that a proceeding has to be initiated, whether let him answer before the appropriate authority whether it was taught, because that cannot be decided without trial. We are not saying that this writ court can decide on these issues. A proper inquiry should be if he finds that these were not proper.
And prima facie, we find the observations made by the court, more particularly in paragraph 22 and 23, is after thoroughly examining the factual position. In an intra-court appeal, we find nothing perverse to interfere in this. These intra-court appeals are by a third party, by a applicant who was a private respondent in WPA 12-11 of 2022 and WPA 16770 of
If my lord so desires, my lord, let me come with an application bringing those documents before your lordship. If my lord so kindly adjourn, so in that event.
These the applications were filed by the appellant herein under section 340 of the Code of Criminal Procedure, alleging that certain forged documents have been annexed to the writ petition and statements have been made in support of which support thereof, which are false and intended to practice fraud upon the court. The court elaborately considered the various provisions of CRPC and then proceeded to examine the facts and has recorded the following finding. With regard to the two documents which, according to the appellant, were forged documents. At this juncture, it will be relevant to take note of paragraph 22 and 23 of the impugned order, which are quoted here and below. Please quote paragraph. On a careful examination of the finding recorded by the learned single bench, we find that the learned single bench had examined the factual position and recorded its finding, which we finding, and we are of the view there is nothing perverse for us to interfere, with the said finding in this intra-court appeal. That apart, in the penultimate paragraph of the impugned order, the rights of the appellant have been sufficiently safeguarded, wherein the court has observed, wherein the learned writ court has made it clear that the findings have been rendered in the limited context of dealing with the applications under section 340 CRPC and are confined to the allegations pertaining to whether the ingredients of the said provision are attracted in connection with the dealings before the court, and nothing in the observation shall prejudice the outcome of the independent criminal cases or investigation, if any, otherwise going on against the writ petitioner on the complaint of the appellant/applicant in respect of the self-same documents. Thus, we find no grounds to interfere with the impugned dismissed. Both the common orders of 3 and 4. Sorry, next.
Serial number 527.
Dismissed, my lord. This matter is dismissed.
I beg to appear for the state, my lord.
Dismissed, sir.
Dismissed. Led by Mr. Learned Advocate General, my lord. As I intimated by the AG office, my lord, he is still not recovered. Lordship is pleased to.
As I was made a submission, and it's for me to give the reply.
In his presence, it is better.
Yes, it is required, my lord.
When the learned advocate.
After 3 weeks, my lord.
3 weeks. There is no urgency in this matter.
Urgency was there because of urgency for the client.
Accommodate himself, please. Adjournment is sought for on behalf of the learned advocate general. Give a date after 3 weeks.
Serial number 8.
May I retain the same position on the next
under the same caption.
Or copy kollo.
Serial number 8.
Date, may I only note the date?
3 weeks.
3 weeks.
Oh.
For the 6.
I'm grateful, man.
I'm grateful, man.
8, my lord, I am appearing. Well, there are few corrections in the order.
What is the?
But let, yes.
In the photocopy, if you correct and give it.
Yes, I have done that. My lord, only dates, my lord. Because the initial order, my lord, in appeal, it was passed on 23rd of December. Yes.
Give the photocopy.
My lord, I have given. There are 4 dates which are needs to be corrected. Nothing else. From the next page.
So the MAT number is also wrong.
Yes.
2017.
Yes. And my lord, the first correction, my lord, the order, initial order, which was passed up in appeal, it would be 23rd of December and thereafter 3.
The matter has been listed under the caption to be mentioned and pointing out certain corrections in the case number and 4 dates.
4 dates.
In paragraphs 1, 3, and 3. The case number shall be corrected as MAT 1803 of 2017. This order shall form part of the order dated 6/8/2024 and the corrections be effective. Next.
Great.
Serial number 9. My lord, I was appearing, my lord, for the alleged continuer in 8.
And I appear for the appellant on the last occasion. I appear for the respondent writ petition. I will. And your lordships have been pleased to,
My lord.
direct.
May I file the report, my lord?
Lord, we have received a copy of, my lord, the report. Lord, we have by a letter, my lord, written to my learned friend, my lord. Most of the pages of those report, my lord, 10 pages, are illegible. So we have asked for, my lord, the.
I'm making. Kindly.
It's just been handed over. Now, this is with regard to construction of, my lord, a pipeline overhead, my lord, the railway underpass, my lord, that right of privilege. That's the issue, my lord. The factory will be running out of water after some time. We are somehow managing. If your lordship kindly fixes it up next week or subject to lordship's kind consideration any other day.
Exception. Lord, we're in the process of filing an exception. We shall do so in the meantime, my lord, and serve copies.
All right. Report on behalf of the Railway Administration has been filed, copy of which has been served on the learned advocates for the parties who pray for time to file their exception. Let such exception be filed during the course of by Friday.
Lord, 1 week's time, my lord, because these are technical presentations.
Shall be filed within a week from date. List the matter on so and so date.
Third or fourth, not that week.
Serial number 10.
But could it be on the first week of September if it's so common?
Anytime.
First week of September.
Next, Lord.
Serial number 10.
Serial number 10.
This is the first time it is coming. Fresh matter 2023. Okay. All right, sir. None appears for the appellant. Give a date after 2 weeks.
Serial number 11.
11, my lord, is my appeal, my lord. On the last occasion, my lord, the lordship had directed us to serve. Lord, the respondent, Lord, my advocate on record, my lord, I don't find, Lord, I don't know whether it has been served or not, Lord. I think it should have been in the meantime, Lord, since nobody is appearing.
Vidyut Kumar Halda.
Yes.
The learned advocate for the appellant requests time to complete service of notice on the learned advocate appearing for the contesting respondent. List after 2 weeks.
Yes. Serial number 12 and 13.
Yes.
My lord, I am appearing for in both the matters for the appellants. My lord, in the last 2 occasions also the respondents are not appearing. The lordship, I would give a notice, and if the matter can be fixed after 2 weeks.
All right. The learned advocate for the appellant is directed to serve notice on the learned advocate who is appearing for the.
Your lordship, it would be better if I give the notice to the respondents because the Competition Commission of India is the respondent. So it would be better.
Who will appear normally for the competition?
Your lordship, in this matter, Mr. Tilak Bose was appearing for the commission at the first instance, and thereafter the then additional Solicitor General Ms. Diwan was appearing for Competition Commission. Yeah.
Already you serve the respondent.
I serve the respondent.
In addition, if you can give copies to the.
Your lordship, we'll do that.
The learned advocate for the appellant shall serve fresh notice on the respondents, and in addition, serve copies on the learned advocates who appeared for the respondents before the learned single bench.
Grateful, your lordship.
Give a date after 2 weeks.
Grateful, your lordship. Much obliged.
Serial number 14.
Your lordship, I am appearing for the appellant, your lordship. Your lordship, on the last occasion, with humble apologies, your lordship, we had sought time for rectifying the defects, your lordship. We are to file one section 5 applications, your lordship. It's there, just the
To file it
affirmation.
today, we'll have it next week.
Next week, your lordship.
All right. Leave is granted to the learned advocate for the appellant to file the application under Section 5 of the Limitation Act during the course of this week. List next week under the same caption. Next.
Serial number 15.
Appears of the respondents. Well, it's on last occasion, since AG was not, learned AG was not well, they have taken time.
AG was appearing
Yes, ma'am.
already. It is submitted that the learned advocate general is appearing in the matter who's not available. Give a date after 3 weeks. They told that he will be able to join after 3 weeks.
Serial number 16.
None appears for the appellant. Give a date next week.
Serial number 17.
Same order.
Serial number 18.
I'm not a respondent in petitioner.
Why today nobody is appearing?
You are not in a position to proceed the contempt application also, since the appeal is pending. Not today.
None appears for the appellant.
Not make it not today.
All right, not today.
We can take it.
Serial number 19.
Not today.
Serial number 20.
And I'm for the writ petitioners appellants.
25.
Respondent who CESC served.
Served. Affidavit of service.
After September.
Served on all concerned. All the respondents.
Oh, the advocate was here for a couple of matters before. Mr. Rai was here, Om Narayan Rai.
Well, the matter concerns as to whose name an electricity meter would devolve after the death of the original consumer. Well, in this case, the petitioner number 1 is the son of the deceased. The petitioner number 2 is the widow of the deceased. And one of the private respondent happens to be the married daughter of the
Next week.
of the deceased. Well, what happens after the death of the original consumer? The private respondent, who happens to be the daughter, somehow manipulated with the CSC Limited and got the meter transferred in her name, exclusively in her name.
Serial number.
The son was there, the widow was there, but she somehow got it transferred in her name by manipulating with the CSC. Immediate, and even a bill was issued specifically mentioning that she is now the meter lies in her name. I have enclosed that. Immediately on getting to know of this, the appellants, that is the son and the widow, immediately approached the CSC, and they came up with a second bill for the next month, reverting the matter back to the name of the deceased. Now the private respondent, as writ petitioner, approaches the writ court, and Justice Shobbhusachi Bhattacharya of this court observes that let the meter remain in the name of the deceased till the civil disputes and partition suits are sorted out in between the parties, all the parties, and directs the party, that is the writ petitioner private respondent hearing, to approach the GRO, grievance redressal officer, in order to sort out the issue of splitting of load only. That transpires from the order passed by the Honorable Court. Now, what the GRO does not decide the issue of splitting of load. I was not given a notice. The GRO does not decide on the issue of splitting of load, but the GRO comes to an observation that she has a right to have a electricity connection in that premises. She is a cancer patient, so let her enjoy the electricity meter in her name. We prefer an appeal before the learned ombudsman. The ombudsman says that the GRO didn't do it right. The GRO should have dealt with the issue in question. The GRO did not decide on the issue of splitting of load in terms of the observation made by the Honorable Court. The order seems wrong, but okay, let the meter revert back in the name of the deceased. But in the event the lady, that is the private respondent, married daughter, she comes up with an application, it will again be changed. The meter will again be changed in her name. That was done. Challenging that, I came up before the writ court again, and the Honorable Justice Khampa Sarkar, Lordship observed that let it continue till it is already in her name, let it continue till the civil disputes are sorted out.
No,
And I am here.
So suit for partition, is it?
Suit for one, there are two suits. One is a suit for partition between the legal heirs of the deceased.
And the second one is the married daughter somehow coerced my mother and got a gift deed transferred, transferring her 1/3 share in her name.
Mother's 1/3 in her name.
My mother's 1/3. So that my mother has already filed for a suit for cancellation of gift deed.
All right. In
So
both,
these two are pending.
both the suits, are there any interim orders?
There are no interim orders.
CESC is not a party to the suit.
CESC is not a party to these suits.
But under what circumstance? Probably with that gift deed and legal heirship certificate.
My lord, even let us for the sake of argument, my lord, in the event she succeeds in the gift deed, the private respondent succeeds, she gets 1/3 of my mother's.
Her 1/3 share.
Her 1/3 share is there. 1/3 of 50%. My father had another brother. He died intestate, and the brother had gifted his half portion to me. So I am automatically having honor of half and 1/3 of my father. And my elder sister, who is the private respondent, can be 1/3 automatic and 1/3 from my mother if she succeeds in the suit. Otherwise, she has only 1/3.
Even as on date, accepting the case of the sister,
my lord,
your share is more than.
My share is much more. I am not standing in the way of her enjoying electricity. For once, I am not at all standing in the way of her electricity. My only point is, my lord, let the meter revert back to the name of the deceased father till the issues are settled. Or let the meter be recorded in the name of all three. Married daughter, my mother, and
before the change of name,
my lord,
were you heard by CESC?
No. I have endorsed that. And when I approached the CSC that how my mother, she's a spouse, there's an offline application form from CSC by which only a spouse can change the name. You didn't even bother to ask for
back, my lord.
Yes.
Subsequently, it was reverted back to the objection made.
That's what
My
we
lord,
submitted
kindly
before
come
your
to the order impute paragraph 4 and 5. But after that, I think my learned friend should not have any objection to this. Kindly see paragraph 4 and 5. Their right has been protected and he could not show a single document which will prove that the respondent number 6 has got no share in the property.
I'm not denying that.
See, there are two ways of doing it. One is it can revert back to the name of the deceased, or it can be in the joint name of these three people.
I'm agreeable to both.
But why do you take sides?
No, we are not taking sides. We have already
a generation company or a supply company, before effecting change, if all the legal heirs come make a joint application, there is no dispute, no issues. But here apparently there appears to be a dispute, and she is in possession of a registered gift deed. And undoubtedly she is a shareholder. But then you should have heard the other co-sharers before shifting the meter exclusively in her name.
As far as my instruction goes, my lord.
No, what is the present
position, my lord? We have implemented the order of the ombudsman. Whatever is there, we have implemented. Before they filed the suit, my writ petition, last writ petition, we have already complied. And that was brought before the honorable single bench, my lord. My lord, if it has fallen from your lordship, my lord, may I come back with instructions?
My lord, even the GRO's order and the ombudsman order, the ombudsman observes that the GRO is wrong.
You produce the concerned file noting or orders by which you transferred this exclusively in the name
My
of
lord, what happens, my lord, we generally get online application for transfer with certain upload documents. But on the basis of that, we have transferred. The moment we got, on the moment we got,
the document contains a legal heirship certificate and the application has been made by a single individual, then you ought to have put notice and issued notice to the other co-sharers of the company.
Manuel, give me some time, Manuel, I will come back.
And the CSC did not even bother to get a NOC.
Let all of them enjoy the electricity supply. Yes. You don't get into their civil dispute.
I will not. Manuel, kindly give me some time, we will come back with instructions.
Have you served the...
Served, my lord. I have filed the affidavit of service. I have served the married daughter in both her addresses, in this premises as well as the married.
And the learned counsel for CESC Limited. Though the private respondent has been served, none appears for the private respondent. The question which is required to be considered in this appeal is whether CESC Limited could have transferred the electricity service connection exclusively in the name of the private respondent, the daughter of the second appellant, correct?
The daughter of the second appellant.
Second appellant and brother of the first appellant. when the appellants claim a share in the concerned property, all being the legal heirs of the deceased Rabindranath Methi. It is not clear as to how and on what basis CESC Limited transferred the electricity supply from the name of the deceased, namely Rabindranath Methi, in favor of Sumana Adya alias Sumana Methi Adya, the sixth respondent, who is the daughter of the deceased. Admittedly, civil suits are pending between the parties. However, in the civil proceedings, CESC Limited is not a defendant. We direct the learned advocate appearing for the CESC Limited to produce all the documents all the documents based on which the electricity service connection was exclusively transferred in the name in the exclusive name of the sixth respondent.
Well, subsequently to the objection, we reverted back, madam, to the original.
Whether inception was right or not.
As you lordship.
At the inception. List the matter on so and so date. In the meantime, even in the writ petition, she didn't appear.
In the writ petition, she didn't, last round of, she didn't appear.
List the matter on so and so date. What date you want?
As you lordship, please, give me a week's time. I'm grateful.
Under the caption for orders. Next.
Serial number 21.
I'm appearing for the WBACTCF. And I'm appearing for the state matter. I'm for the 5 minutes.
My lord, this is the matter where, my lord, I suffered an order, my lord, from the Honorable Single Judge directing me, my lord, to restore, my lord, the connection of electricity, my lord, to the tenant. My lord, my allegation was that, my lord, the tenant was running a business of, my lord, giving government service in lieu of bribe, my lord, from my premises. And, my lord, there are, my lord, complaints lodged, FIR lodged.
That's why we directed the
Yes, my lord.
advocate for the state.
There is a direction, my lord. I have
To file a-
prepared a report, my lord, in the form of affidavit. My lord. And I'm serving a copy here.
Thank you.
Lordship, apart from this, my lord, I have gathered some other information other than Joynagar PS, my lord. There was a case against in the Regent Park PS, my lord, against the private respondent. In connection with that case, he was arrested and charge sheet already submitted. That report I have gathered today only. I have been handed over this report, my lord. With this report, may I hand over this report, my lord?
Please.
May I get a copy of? Okay.
Multiple criminal case.
My lord, already FIR has been lodged and in Joynagar PS case number has been started and investigation is under process.
And you are appearing for Tapas Chandra. Who's up? And the police says your client is a very dangerous and desperate.
I'll direct to hand over a copy of the report.
Now, what is the order passed by the learned?
Directed to restore the electric connection and with regard to civil dispute within the party civil suit are filed both by both by him and by myself.
But suppose you are carrying on some illegal activity in the premises, like offering government jobs, offering job in the High Court.
That my lord, I have to take instruction because I am not favored with the copy of the report.
My lord, I am handing over the call.
Surprising that my lord, my learned friend doesn't have.
My lord, may I humbly submit in respect of the Regent Park PS case, my lord, there is a serious allegation against him. He defrauded a old and ailing woman during the ATM when she took the help of him, and he has cheated.
And in
This
this
is not
report, is there anything to show that he was doing some illegal?
My lord, till date, I have not been instructed. The investigation is going on, my lord, because the newly started FIR.
Your allegation is he is running a employment center there.
My lord, charge sheet also
And my
started.
lord, my learned friend my lord, appearing for the writ petitioner, my lord, says that my lord, he doesn't have the instruction, though my lord, his client was imprisoned, that he knows.
Nothing was, my lord. Nothing was, and my lord, you will kindly see
Nothing
the
was, Maneki.
there's the application, sir. Nothing was disclosed in the application also.
No, your client should have disclosed to you.
No, my lord, there you will also kindly see the report also.
But I have instruction that there are many other
Person
cases against him.
impersonated himself as Indian Bank official and induced the complainant that he would help her for withdrawing her money from her account so and so in Indian Bank, and thereafter tricked the said person of rupees 49,000.
Yes, my lord.
And gave the complainant only rupees 5,500.
He helped in withdrawing the money from the ATM, and he has taken the substantial amount. Only the little amount part has been given to her.
All right.
And he has introduced himself as a bank employee, my lord. That is also very serious allegation.
In terms of the directions issued on 37/2024, the officer in charge, Jayanagar Police Station, has filed a report in the form of an affidavit dated 14th August 2024, along with annexures. The same is taken on record. The learned advocate appearing for the state has also placed before this court the written instructions given to her by the inspector in charge, Joynagar Police Station. From the report, the copies of the report has been furnished to the learned advocate for the appellant as well as for the learned advocate appearing for the respondent number 1/writ petition, who seek time full stop. The learned advocate appearing for the respondent number 1/writ petitioner seeks time to get instruction in the matter. On a perusal of the report along with annexures, as well as the written instruction given to the learned state advocate, prima facie, it is clear that there are several criminal cases registered against the writ petitioner, and he had also been arrested. Therefore, till a decision is taken in this appeal, the order and direction issued by the learned single bench in WPA 14108 of 2024, dated 21/5/2024, shall remain stayed. Liberty is granted to.
What is happened now is that I'll kindly appreciate. The electric connection, they are already been affected. The connection was, I am enjoying the electric connection. Now, the allegation was that I am running a business on these premises. That is the allegation. You lordship kindly see the report. Is there any which to that extent? I am running a business on
You file a exception. Liberty is granted to the respondent number 1 writ petitioner.
I am enjoying the electric connection. My daughter is, my lord, starting in class 9.
Generator, you buy a generator. Grant to the first respondent writ petitioner to file exception to the report within 2 weeks. Give a date after 3 weeks. Next.
Grateful, man.
Serial number 22.
The copy of the subsequent report.
Yes, my lord, I give.
Serial number 22.
My lord.
Yes.
May it please your lordship, my lord, my affidavit service, my lord, we have already served upon the writ petition. Sorry. अच्छा 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 सॉरी 8 सितंबर
Yes, sir.
I've given instruction. It was picked up on the basis of a requisition given by Bidhannagar. I've spoken to the Commissioner of Police Bidhannagar also. He is released on CR bond within a few minutes. He shall be.
You can inform Chatterjee. You can ask Junior to inform Chips.
So that is done.
Thank you.
Serial number 22.
It is your lordship. My affidavit service we have served upon the writ petitioner.
On what date you served? Yesterday?
No, my
Friday?
much prior, man, much prior. At a copy.
14th August. Probably they'll take some time to appear because intervening holidays were there.
23rd July.
Can you inform Mr. Tanmoy Basu?
My lord, sir.
Notice has been served on the respondents and affidavit of service has been filed. Since none appears for the respondent, we direct the learned advocate for the appellant to serve notice on Mr. Tanmoy Basu, who appeared for the respondent writ petition. List next week under the same caption.
Serial number 23.
In 23, I beg to appear on behalf of the respondent.
Appellant?
I am for the appellant. In this matter, my lord, two orders has been passed simultaneously. One on the same day on which date hearing was taken place. In the website, on the next day, I found that matter has been disposed on. My lord, kindly see the order website case status. That is page number. That's right. 49 of my stay petition or on grounds of appeal also in I have annexed. That is case status. It has been nature of disposal contested, dismissed as withdrawn. It was loaded on the server on the next day of the hearing. Thereafter, after 4 days, the judgment, speaking judgment, was passed by the Honorable Justice, single judge, on 24th on the last date.
What is the civil dispute pending?
Pending, that is was the point, my lord. The backdrop of this discrepancy arises when my learned friend, at the time of moving this application before the Honorable Court, he raised a point that civil suit is pending regarding this issue. But I emphatically deny that no such civil dispute is pending, and the submission is totally incorrect and false. And affidavit should be asked for, and the detail shouting after filing the details of plaint and the case. What is the case and where it is pending? When
who's appearing for the respondents 4 and 5?
I am appearing on behalf of
4. Respondent 5, Popular Enterprise.
It's the publisher.
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 And the learned judge has recorded saying that there is a civil dispute between your client. What is the civil?
My lord, may I be permitted to place this document, which was annexed to the writ petition, but has been left out here. This is the copy which has been annexed with the writ petition, being left out.
You're appearing for the registrar.
Registrar, yes, my lord. My lord, kindly have a look. 2 title suits, one by them, one by them. And in that order has been passed. The civil dispute being going on as to the cause, my lord, they have come up again with the writ.
Now, my lord, kindly see, regarding that.
The civil suit, you should have filed an interlocutory and sought for an appropriate injunction against the 4th respondent.
My lord.
How they can adjudicate this dispute?
As because I am submitting before your lordship why I have filed this writ petition, as because the nature of this prima facie case before your lordship, before the lower court, is that I am publishing one journal that is come within the purview of the Article 19(1)(g), my lord, as soon as I am publishing, and thereafter when I am
Please see the prayer and the writ petition. Mandamus to commanding the respondents. Which respondent you have not said? To desist the private respondents.
if that is the, then I am humbly request, my lord, to amend the prayer so that the respondents upon the respondent number 1. I am not.
You file an application in the civil suit.
No,
get an order of
no civil suit is pending regarding this very matter, my lord. The subject matter is not the lease. The subject matter which is pending before this honorable court is not a matter of subject matter of the pending civil suit. What they are saying.
Respondent has addressed a letter to the that is a department saying that
that is the postal department, my lord. I am, my lord, kindly go through that postal department letter.
That the fourth that who has written this?
Letter regarding what was the subject matter of that postal letter. I am sending my journal on the concessional rate.
Sir, it is your letter. You say in this connection issue raised by you based on the purported letter written by Balram Nath, an expelled member. You have expelled him from Nikhil Bharati so and so Samilini, NBRSR.
That is not it is not from this letter. It is not come out that the civil suit is pending.
Yes. Second paragraph. The alleged order annexed to the purported letter have no relevance to his issue, etc. Circulating the name Shaiva Bharati. In the alleged order dated 9/3/2023, passed in TS number 460 of 2023.
And my lord,
now, my lord, kindly appreciate
what
is the
other
backdrop.
private
My lord,
respondent, the
kindly
other
see the
suit is also
backdrop
pending.
of this letter. Backdrop, without backdrop, my lord cannot adjudicate this letter. Backdrop is we are also publishing, they are also publishing. When both the parties go to the postal department for availing the concessional rate, then postal department stop to me and also stop them and ask them produce original paper who is the real person concerned and registered has been granted by the honorable high competent authority. Then we have placed all the relevant paper regarding our registration number and the sanction granted by the respondent number 1. After all examining all these papers we have produced, then the postal authorities allow us to take concessional rate and rejected their prayer. This is the backdrop of this letter.
Where is the rejection order?
Rejection order of their letter, of their see, my lord, paragraph, see the letter. Page number 36, my lord. Page 36 and 37, my lord. With reference to the application such as regarding ATO, it is intimated that your publication has been granted renewal registration in favor of us for the calendar year 23 to 25. And their return has their renewal registration has been rejected.
Where is that rejection?
They have only they have written in response to our letter that you have your renewal application has been allowed.
This is a reply given to the postal department by your client to their request not to allow concession to you or to allow concession. I think I am not made myself clear. Page 37.
Page 37, my lord. Permission for posting in favor of us. Headline subject the permission for posting on behalf of the self. They have granted permission in our favor.
Where is the permission granted to your client?
No, they have not. They cannot show it.
Fact is this, my lord, this society is formed by the members. And then lastly, election was a general election was held in the year 2022. But in the election, this appellants was both the appellants were defeated in the election when they are participating in that election. After election is over and new committee was formed, but all the papers, original papers were handed over to this new members, new committee. Present, my lord, respondent number 4 here, my lord, is the secretary, and he is the editor. Well, after new committee was formed, the paper, this magazine was started to be, my lord, published. But my lord, this person, but appellants are, my lord, influential persons. My lord, they have tried to invade the office, and my lord, tried to capture all these things. Banks books, even, my lord, all these things. And, my lord, for this, their wrong action, my lord, this particular, my lord, respondent number 4, filed this suit. Civil suit, in the civil suit, my lord, there is a injunction restraining the respondents from peaceful and
Interfering with your publication.
yes, they have been diseased from publish. My lord, in the
Where is the copy of the injunction order?
My lord, injunction order is still continuing. My lord, still continuing.
Then you-
Now I am.
Did you
They are the
disclose,
parties. My lord,
did you disclose the pendency of the civil suit?
Now, my lord,
Please answer this question, sir.
as because that fact, the civil suit, my lord, kindly appreciate the civil suit related to the rivalities of the functions regarding the which group, the which that is
Matter relates to a publication.
no.
Whether you have got a right to publish or whether he has got a right to publish. He has gone before the civil court saying that they are the rightly elected body who can and there is an order of injunction against your claim. What you should have done is you should have put one paragraph, civil suit is pending, but however, because of so and so
That is,
reason,
we have not suppressed. Then my lord, my lord is my lord kindly shifted us burden that I have suppressed that facts of civil code. That is not a material fact in the material fact.
That's not for your client to say, it is for the court to say. It is the duty of the client to disclose full and true disclosure of all proceedings pending, pending intricacy between both parties. Then you say this civil suit will not impact the relief I have sought for. Sir, above all, we cannot grant any injunction against a private party.
Then my lord, kindly affidavit exchange will then disclosing their
all right. This intra-court appeal is directed against the order dated so and so in WP 1255 of 2024. In the said writ petition, the appellant had sought for a writ of mandamus to command the respondents to desist the private respondent number 4 and 5 in the matter of publishing, printing an alleged magazine under the name and style Shaiba Bharati, which according to the appellant is a counterfeit magazine. The learned writ court had considered the facts and found that civil proceedings are pending between the parties. The learned advocate for the respondent, fourth respondent, submitted that the appellant had resorted to objecting to the publication made by them after he was unsuccessful in the elections of the general body. Furthermore, a civil suit has been filed by the organization against the appellant and there is an order of injunction operating. In the writ petition, the pendency of the civil suit has not been disclosed. The learned advocate appearing for the appellant would vehemently contend that the civil proceedings have no impact on the relief sought for the writ petition. It is not for the appellant to say so. The duty of the appellant, who was the writ petitioner, is to disclose all facts fully and truly. And if, according to the appellant, the civil suit has no impact, then such a pleading should have been made in the writ petition. In the absence of the same, we find that the relief sought for could not have been granted and rightly the writ petition was dismissed. We find no grounds to interfere with the order passed with the single bench. Dismissed. Sorry, sir. Next. Next.
Item number 24.
Lord, I am appealing for the state respondents.
Lord, item 25, I appear for the appeal in Millard. Seeking for a day's accommodation, Millard.
Not
have no
today.
instruction, my lord, whether the appellant wants to pursue the matter, because on the earlier occasion, my lord, I had submitted that talks of settlements are going on between
All
the
right.
parties, my lord.
Not today.
My lord.
Next.
I do not 25.
In this matter, I am appearing on behalf of the appellant petitioner.
Respondent served.
Yes, we have served all the response. This is affidavit of service. Without service of notice upon us, my lord, this matter was heard and this order challenged, my lord, past ex parte, my lord.
But the court says affidavit of service filed in court by the petitioner taken under.
Petitioner, my lord.
The first paragraph of the order.
Upon the state respondent, my lord.
Not on the private respondent.
Yes, upon the state respondent, not the private respondent.
In your memo of appeal, have you stated so?
Yes, yes.
Have you raised such a ground?
Page 69, also page 69.
Page 69.
Page 69 of the CAN application.
Page 69 of the CAN application. Oh.
You say no notice of upgradation was served.
Yes, madam.
Notice was served. It was running in the item 586.
Yeah,
the matter was upgraded.
Page 69, my lord. Matter was appearing in the combined list as 597. Thereafter, my lord, page 71, paragraph, page 71, my lord, item 14, upgraded motion without service any notice upon the private respondent. The matter
And what
was
is the direction which has been issued? What is the order which has been passed?
Order, my lord. This is a, they preferred the writ petition, my lord, against inaction on the part of police, my lord.
No, writ petitioner claims to be a owner of a plot of land.
Yes.
And he intended to raise construction.
Yes, my lord.
He obtained permission from the Gram Panchayat.
Civil
and you are preventing him from doing.
No, no, my lord. Civil suit is pending. This is
where is the plaint?
Plaint, my lord. Page 117. 117 of the CAN application. Well, a writ petitioner was a stranger purchaser. It is joint property, my lord.
In the writ petition, they did not say about the pendency of the civil suit.
No, no.
Petition can start with certain
This intra-court appeal is by the private respondent number 5. Your client was the 5th respondent in the writ petition. Respondent number 5 in WPA 4205 of 2024. The said writ petition was filed by the respondent filed by the 5th respondent herein, namely Vishwanath Maiti, to direct the police authorities to take cognizance of the offence on the basis of a complaint dated 30/1/2024. The learned advocate for the appellant submitted that the writ petition was running in the combined monthly list as serial number 597. And without serving any notice on the appellant, the matter stood upgraded as item number 14 on 12th July 2024. And without hearing the appellant, the writ petition has been disposed of. It is submitted that two civil suits are pending in title suit number 31 of 2001 and title suit number 40 of 2014 and title appeal number 48 of 2013 is also pending. It is submitted that the writ petitioner is a third party purchaser. And according to the appellant, the seller of the writ petitioner is not the owner of the property. Thus, when title suits are pending, the order and direction issued by the learned writ court will cause great prejudice to the appellant and would affect the civil proceedings. As we are prima facie satisfied that the appellants were not heard in the matter, apart from the fact that we find from the writ petition the pendency of the civil suit has not been disclosed, though the writ petitioner was a defendant in the civil suit. For the above reasons, the appeal is entertained and the order and direction issued by the learned single bench dated 12/7/2024 in WPA 4205 of 2024 shall remain stayed. In the first paragraph. You have given your affidavit of service?
Yes, affidavit of service already filed.
Affidavit of service has been filed in court by the appellant and the same is taken on record. Yes, next.
Item number 26.
Lordship, kindly take up the matter day after tomorrow. Advocate or record is not present. Lordship,
After
you will
tomorrow,
come.
I have some difficulty, Milord, then next Tuesday.
I have
Subject to your lordship.
Tuesday.
Next Tuesday.
Lordship.
At the request of the learned counsel for the appellant, next Tuesday, under the same caption.
I'm deeply obliged to your lordship.
But I have instructions to appear on behalf of the respondent number 7.
So you give your names. Next.
Item number
He has already
27.
appeared in low court below.
27.
High court below, single, both the lines single.
27.
27, I am for the appellant writ petitioner.
This is what I have for the statement.
The crux of the matter is that, my lord, your petitioner is the contractor under the, my lord, Bhatpara municipality. He is engaged in the, my lord, different development work. There is a different nature of job, that is repairing, restoration of the road, drainage, construction of the pathways. What has happened since the month of August 2017 to July 2019, different work orders has been issued by the then chairman of the Bhatpara municipality in favor of the petitioners. Writ petitioners appellant before your lordships. He completed the job with the satisfaction of the Bhatpara municipality. Now, my lord, there is a due of rupees, my lord, 52 lakhs, 75,907.
File a civil suit.
Well, what is on the similar occasion, my lord?
They
your
are
lord,
saying that you are
well, on
some
these
fake documents.
well, kindly look to, my lord, the order passed in, my lord, another matter which is at page 120, and subsequently the authority preferred an appeal, and your lordship was pleased to give direction to disburse the same, affirming the judgment of the single judge. My lord, kindly look to page 120.
In that case, probably there is no allegation of
But
fraud.
the order, kindly look to the order impugned, wherein, my lord, it is
If
stated
the
that
agreement contains your client has been blacklisted. And
Lordship,
according
the
to
issue in
blacklisting and completion of work is
so the
totally
issue
different.
in 120 is, I sustain, whether the state government will come to bail out the municipality in that.
That we remember.
Yes,
The
and
penalty
then
we
lordship in this matter is pending before Supreme Court. We are also contesting that no, it has to be because I am a creature of the state. I am appearing for the municipality there. So lordship, this case has no bearing with this. This case is on a pedestal that the work order itself was fraudulently obtained. Then lordship, loan was taken from a nationalized bank. And then lordship, there was no action or act done. And then lordship,
May I give reply, my lord?
This
The
may be,
work
this
order,
may
my
be
lord,
wrong,
is
but
not
that's
the-
the prima facie
Case
fine.
is pending. FIR has been registered. Let the investigation go
No,
on.
no, my lord, what has happened, my lord? I annex the, my lord, charge sheet, wherein, my lord, I can establish before your lordships, my lord, the work order is not the subject of the criminal trial. Well, it is a,
We can't
it is,
decide that, sir. You please go before the civil.
well, kindly look to my lord, page 84 once, no work order, single work order, my lord, is, my lord, subject matter of the criminal trial, my lord. Page 84, my lord, kindly look to my lord,
We
page
can't
84
go into
once.
that, sir. You know better.
Page 84, this is a letter by the then chairperson saying that, my lord, upon the, my lord, honorable minister in charge, requisition of fund in respect of the petitioner work also. Kindly look to, my lord, page 84.
77.49 crores.
And kindly see, my lord, the name of the petitioner is at page 88. Page 88, serial number 175.
So a large scale fraud, sir.
175, Nanni Singh,
Nanni
the
Singh.
appellant before your lordship.
Issued on 2022.
And it is issued on 2022. And the criminal case lost by the 2020. But after issuance of the criminal case, my lord, the chairperson issued a requisition before the state government for requisition of fund in the name of the appellant and other satisfactory service. But kindly look to, my lord. But the none of the work order is the subject matter of the criminal trial. That's why, my lord, I annex the, my lord, charge sheet also.
How are to we to
But kindly
decide
see
that?
the observation of the single judge. Kindly look to, my lord, the observation of the single judge. Order impugned. Kindly look to page 9 July 2024. There is a observation that petitioner also relies certain document, and kindly come to the last paragraph. The third part is submit that by showing the fake work order issued
No,
to the
according to
municipality.
you, the criminal case, the charge sheet does not concern this work order.
Yes.
Work which you have completed.
And criminal case had not been initiated against me.
I'm the witness.
I am the witness there.
Your criminal case has been initiated against the SOL chairman of the municipality, probably minister in charge also.
Well, I am not the, my lord.
77 crores.
I am not the accused in respect of this case.
All right, somebody, forged a work order and gave it to you, and you did
Well,
the work.
I filed
And the work order is fake, no work carried out, bill raised, then you come.
Well, I filed the instant appeal for the observation made by the honorable single judge. Kindly look to, my lord, the second page.
That is claiming money for a bridge which was never built, for a road which was never laid.
Partly I have paid from my bill. Kindly to look to the receipts.
Yes, sir, we heard you. This intra-court appeal by the unsuccessful writ petitioner is directed against the order dated 9/7/2024 in WPA 25080 of 2023. The writ petition was filed for a direction upon the respondent municipality to settle the claim made by the appellant writ petitioner for alleged work done for the municipality. The learned single bench noted the facts and that there were criminal cases registered, and according to the municipality, fake work orders were produced, etc. In any event, a disputed money claim cannot be, a money claim cannot be adjudicated
after satisfactory service, my lord,
when there is a dispute. Therefore, the observation of the learned single bench that the writ petitioner is at liberty to approach the civil court is fully justified. Thus, we find no grounds to interfere with the order passed by the appeal fails.
well, against the observation made by the honorable said something, my lord,
needless to
be there. Otherwise, my lord, the municipality nothing.
Needless to state that the observations made by the learned single bench will not stand in the way of the appellant working out his rights before the competent civil court. Next.
Obligement.
Item number 28.
Yes.
Lordship, I am on behalf of the appellant, advocate on record suffering from corona. So kindly give.
No copy has been served to the statement.
What was the report? Oh, you are not aware.
I am not aware.
All right. Even last occasion, nobody appeared. Sir.
Okay.
Adjournment is sought for on behalf of the learned advocate for the appellant on the ground of ill health. Adjourned. Give a date after 3 weeks. In the meantime, the learned advocate for the appellant shall serve the learned advocate appearing for the state. Next.
Item number 29.
In this matter,
Appellant, I have
Yeah.
served the copy. This is my.
in this matter, Lordship, Devniya Lari is appearing for respondent Max. She has some personal difficulty. Lordship, kindly praying for not today only.
You have been served?
Yes.
Lordship, one copy.
I have served.
Kindly keep it not today, Lord.
No, notice has been served on the respondent. Affidavit of service is filed, which is taken on record at the request of the learned advocate for the respondent. Next week. Next.
Item number 30.
This matter, will have no notice is served in the office of the Ministry of Law and Justice. And that too, one notice has been served from the learned advocate who appeared before the learned single judge that it will be taken up tomorrow. So kindly take it up on Wednesday. I have talked to Mr. Mojumdar.
Ministry of Law and Justice রেলওয়ে এর মামলা নিতে চায় না বলছি
না কে বলেছে কি?
এই ছিল
48 hours এর গ্যাপ থাকলে নিশ্চয়ই নেবে। Otherwise, the writ petitioners are protected till 31st August by the only single judge's order.
August.
You are an encroacher or you are a permissive occupant or a licensee?
I'm not a licensee.
I don't know.
This is outside the platform.
Yeah, why you encroach the platform?
No, it's outside.
On the track also. Why are you worried? That is the order of the day. State of West Bengal, I have got a right to encroach. And the respondents cannot throw me out. My liberty, this guarantee, 14, 19, 21 affected. Why? Because I am occupying government land.
No, it is the specific case of the writ petitioners before the learned single judge that they were doing business on the railway land.
I'll show to Lordship not when it
No. Secondly, if Lordships actually peruse the learned single judge order, this is a detailed reasoned order. There are 3 issues before the learned single judge. One is whether a person can move a writ petition in the name of a cooperative society without disclosing who are the encroachers, who are in occupation of the railway land. Therefore, the writ petition was misconceived, number 1. Number 2 is, even if some persons occupy the railway land for running a business of selling food, they are required under the law to take 2 licenses. One is license to run the business and the license to serve food, because there may be contamination. And third is, whosoever is the encroacher, there are a number of judgments of this honorable court, even the division bench, that under section 147, they can be removed from the premises without even giving them an opportunity of hearing. Here we have given opportunity of hearing on 2 occasions, 2 notices have given.
All right, Wednesday.
Wednesday.
At the request of the learned additional solicitor, list on Wednesday under the same caption. Meantime, can you get some photographs?
Well, I said try to get.
No, easily it can be. They can click it, send it through WhatsApp, you make a printout or soft copy you show to us. And how many of them are there?
50.
Lovely.
Have you disclosed in the writ petition? There are 50.
I have.
Then why don't you construct a multi-story complex for them?
No, that's the idea of the central government to construct
this
a
is
multi-story.
These have no semblance of rights.
No, I'll show to your Lordship what the
100
has
years,
done in
1000
this.
years you be there.
But the
Entire
proceeding
India.
proceeded to a certain extent for the purpose of granting lease.
No. My
learned
friend is not at all correct.
No, who is the general manager to part away with railway land? He has got no jurisdiction at all.
I'll show to you.
Unless and until the railway board takes a decision.
Secondly, my lord, it is Amrita Bharat Yojana. Throughout the country, the railway platforms are being renovated. And in that circular also, there is a provision left after the renovation. They shall be entitled to make an application for lease or license. That protection has also been given. And the London Single Judge has categorically recorded that on the issue of livelihood.
We can probably extend the protection for 2 or 3 months.
Come back on Wednesday. I'll show not 3 or 4 documents and their guidelines not when they proceeded to a certain extent.
Next.
Item number 31.
31, I am for the appellant. Lordship, actually, on last Tuesday, Lordship, this matter, Lordship, I have prayed for your Lordship's leave to file without certified copy, Lordship, with a returnable date on 27th August, Lordship. Now, somehow it appeared to Lordship. I am praying for not this week, Lordship. Because in this week, Lordship is supposed to file a stay application, Lordship, that I could not do this. I'm praying. Only not this week, I'm praying.
At the request of the learned advocate for the appellant, list next week to enable the appellant to file the stay application.
Lordship.
List next week under the same caption. Next Wednesday.
I'm grateful, Lordship.
Item number 32.
I beg to appear in this matter. Lord, eventually, this matter against the order of the Green Tribunal, Eastern Zone, my Lord, National Green Tribunal.
It is provided to the Supreme Court.
No, my Lord, subject to kind sanction, my Lord. This matter should be filed in terms of your Lordship order. I have the copy of the order before the single bench. My Lord, I'm giving the copy to Lordship. My Lord.
But whether it is maintainable before the single bench?
Yes, that is also not maintainable. I'm showing
go before the National Green Tribunal.
National Green Tribunal's orders are to be challenged before the Supreme Court.
My Lord, if a Lordship, let me just.
Maybe there is an order of my lords, but then.
এটা দেখো তুমি দেখো আমার সাথে কপি পাওনি এটা এম্বারাসিং সার্ভিস হয়েছে মেলে কিন্তু মেলে হ্যাঁ
No, I think there was an appeal against this order, this single bench order.
Lordship. My Lord, initially an appeal was filed before the division bench, then this elaborate matter was taken up, and thereafter
Against this order, I think we have entertained an appeal.
My Lord, that updates was not with me, subject to kind sanction, my learned senior friend also.
I remember correctly, I didn't hear.
So your Lordship,
There was a case, whether this case or the another case, your Lordship's view was that you should move this.
My Lord, better for amendment precaution, your Lordship make some pending for a week so that we can take updates and come returnable, then your Lordship can. That will better.
At the request of the learned advocate, appeal.
Judgment.
This next
Judgment copy আমাদের
same caption.
আমার নাম্বারটা দিয়ে
দিয়ে দিচ্ছি আমি তুই ওপরে ছবি তুলে না
If it is there, print out of that order can be kept inside.
Hello, next week any dates?
Next Wednesday.
Next Wednesday. So kind of Lordship. Lord, this question also harping, I tried to find out, but I didn't get. No, I mean, judgment of it after the Duchess.
I don't know, 33.
Make results.
Up to 150.
32.
আর একটা ফিক্সড ম্যাটার আছে জুনিয়র আছে আমাদের রিপ্লাই আমার জুনিয়রকে বলে দাও বুঝতে পারছি না কি পজিশন নেক্সট ওয়েডনেসডে কোন আজকে 115 একটা কি মার্চ ফার্স্ট আছে না সেকেন্ড হাফে দেখুন
You are referring to paragraph 18 of the learned single justice on the last occasion. No, you can start from wherever you want.
Lord, on previous occasion, my Lord, when I have already placed clause 4.7, it was fallen from your Lordship that other three conditions are there which are required to be adhered to in construing the provision of the clause 4.7. Since, my Lord, it has been mentioned in the clause 4.7 in the last sentence that the, my Lord, the clause subject to the, my Lord, following conditions. Kindly pause for a moment, my Lord. The conditions, my Lord, with a view to interpret the clause 4.7, our duty is to, my Lord, to construe all the contracts in totality, because when so many decisions are there, your Lordship is, my Lord, is the same view. And other the clauses are there, whether these clauses are in aid of the, my Lord, clause 4.7, the principle. Your Lordship is aware that so far as the commercial contract is concerned, nowadays, after the promulgation of the, my Lord, General Agreement for Trade and Tariff, normally most of the, my Lord, the tenders are the global tenders, which, my Lord, is range is more than 100 or 200 crore like this. In all tenders, normally there is a, my Lord, form 2911 that was in the year of 1952, that was prepared and drafted by the central government CPWD, and subsequently that has been copied in all the state governments of different states. And in West Bengal, that is called 2911. All the clauses are in favor of the one of the parties, of the employer. So initially there was a challenge whether, my Lord, the bargaining power is with the, my Lord, or not. So, my Lord, there are the decisions which says that no, this is a one-sided, and that has been interpreted subsequently. After the, my Lord, the promulgation of this, my Lord, the open the, my Lord, the agreement, all the countries, my Lord, who intending, my Lord, to do the business in India also, they have given a specific standard bidding documents. Different forms of the, my Lord, the agreements are there. That is standard bidding documents, FIDIC form of contracts. If your Lordship see, all the contracts are such, even in the, my Lord, the so far is Asian Development Bank or any other bank are concerned, they are giving a, my Lord, voluminous document of standing bidding documents, standard bidding documents, on the basis of which sub clauses are there. All the clauses are in favor of the employer as well as are in the favor of the, my Lord, the contractor also. So this is also the one piece of the such kind of a contract document on the basis of which standard clauses are mentioned over there. This contract, my Lord, kindly see the first one pertaining to the defect liability clause. Our nature of work is excavation of, my Lord, the overburden and transportation by employing or, my Lord, the transport system or all those things, and few machineries are there. Here the, my Lord, issue of defect liability clause is not there. Since the defect liability clause is not there, therefore, my Lord, 4.7a is of no relevance, is completely osseous. So far as the B is concerned, this is pertaining to, my Lord, the building contracts. It is not a building contracts. Therefore, my Lord, we cannot take any aid from the B also. Third one is, in case of the supply, installation, commissioning of the equipment of the electrical and the mechanical works, the refund shall be made after the expiry of the defect liability period. So, my Lord, three of the clauses doesn't have any relevance so far as the present contract is concerned. If we consider, if your Lordship consider, any of the clauses can be interpreted with a view to construe the original 4.7 clause, in that event, my Lord, only we can say that the period which has been mentioned, the 6 months, that can be extended where there is a defect liability period is concerned. But in my, my Lord, little understanding, my Lord, any of the clause doesn't have any relevance in construing the clause 4.7. In a different way, if I put it, because, my Lord, while I was reading, it was in my mind that, my Lord, somehow your Lordships were thinking that whether this is or the, my Lord, the trial court observation can be seen that it is a rewriting of the contract or not. The confusion is there. To allay any confusion, what, my Lord, I intend to say is this. My Lord, the Honorable Trial Court said that the word shall has been used over there. So therefore it is mandatory. whether any particular clause of a contract is mandatory or directory, twin tests are there. The first test is whether non-compliance of the provision having any clause for punishment or the penal action. If you don't do it, this would be the consequences. This penal clause is not there. So my case would not become under the purview of the first one. The second one is this. It has been categorically stated that if the object of the clause is defeated by the non-compliance with the provision, then it would be regarded as mandatory. Honorable Supreme Court has said so in a decision reported in 1981 SCC 403. This is a settled principle. So why I am telling so? Suppose kindly construe a situation for an illustration. My work has been completed. There is a completion certificate. Completion certificate was issued on a particular date, that is for illustration 1st of January 2024 for an illustration. I am entitled to get, there is no dispute, on the 2nd day of January 2024, the first of the half of the amount. There is no dispute. What is pinching and what is troubling your lordship is whether the outer limit of the 6 months can be said so, can be read down like this way or not. My little understanding is this. What is the purpose of giving 6 months? If I think it in a different way, suppose 6 months period has not been mentioned. That means, an option has been given to the employer to exercise his discretion for a time period so that they can think whether there is a due pending or not. If I think it in a different way, like this, that the 6 months period, as to why the 6 months period has been mentioned over there, I cannot construe something which does not have any reasonable basis. The purpose of this, the situation is, the purpose is this, that in a changing situation, when on the basis of the ease of doing business, our endeavor would be to interpret any clause which give a business efficacy and the business common sense. If something we cannot construe like this way, that it can give a dividend to the one party, at the same time other party would be vanquished. So my understanding is this, 6 months period has been mentioned, particular phraseology has been mentioned with a view to get a outer limit. So that if there is anything, one illustration was fallen on previous occasion, that after completion, first half has been given. Thereafter, a demand came. Naturally, they can do so. They can deduct or appropriate, subject to that demand was prevailing within the period of the 6 months, which has been mentioned over there. Even in the principle of the so far as the contra proferentum clause is concerned, although this is not applicable, there is a dispute that it would be applicable in case of the the insurance clauses or the clauses pertaining to that contract also. But these basic principles has been taken in interpreting the commercial clauses also. It says if there is any ambiguity or if there is any the difficulty, in that event, the clause would be interpreted in such a way that would be in the favor of the person concerned against the person who has drafted it. This document, no doubt, that has been drafted by the employer. Even then, they consciously, incorporated the period of the 6 months. So, the Honorable Trial Court has taken trouble. So, I was also thinking, if with an intent to interpret this clause, is there any necessity of making that this is the outer limit of 6 months? There is no necessity. Even then, if the particular word can be, or the observation can be deleted, in that event also, my purpose would not be frustrated. With a view to adjudge whether there is an arbitrary action or not, they have to come in a clean hand, saying that after completion of the work, we did so. They have defaulted in not giving or not disbursing the first half of the amount on the next day of the completion. Because, my lord, there is no discretion, which has been mentioned, that if your lordship see that, my lord, on completion of the entire work, after the first clause, on the completion of the entire work, the certified as such by the engineer in charge, 1/2 of the security deposit remaining with the company shall be refunded. I am not on the second half. So first half also not been given to us. There is a patent arbitrariness on the part of the, my lord, the authorities by not disbursing the initial amount which has been required to be passed. The second portion is, even then, my lord, we see the second half also, that has also not been given within the 6 months which has been mentioned. See, if we construe the provision, leaving aside the, my lord, the time which has been mentioned over there, in that event, we can already construe what was the intention of the, or intendment of the, my lord, the draft, who has prepared the draft of the, my lord, the contract. So, my lord, kindly have a look at the provision, my lord, which I have shown to your lordships on previous occasion. My lord, 33 is very relevant. I have already, my lord, for the cost of the reputation, my lord, on previous occasion I have placed it. Kindly excuse me. The proposition laid down in the Indo Development Authority supra in the relevant in the context. The judgment lays stress on the paragraph 33, my lord. The proposition laid down in the Indo Development Authority supra is relevant in this context. The said judgment lays stress on the doctrine of the conundrum ex injuria sua nemo habere debet, meaning that the convenience cannot accrue to a party from his own wrong. That means they have sat tight over the matter. They did not do so. Subsequently, they came and say that, no, I do have right. What ought to have been done immediately after completion of the work, they did not do so. Therefore, there is a, my lord, arbitrariness on the part of the authority in disbursing the amount. Subsequently, they come forward and say that, no, my right has come because there is pending dues. I can adjust. My lord, kindly have a look at paragraph 35. In the present case, job completion certificate was issued on the November 19, 2022, and the period of the 6 months thereafter has elapsed long back. The counterclaim sought to be set up by the respondent was raised on January 1, 2024. Much after the expiry of the 6 months from the job completion, even after the filing of the writ petition. Hence, the said claim did not see the light of the day within the stipulated 6 months, up to which the such claim could be deducted from the security deposit to be refunded. Hence, it is too late in the day to deduct such amount. The delay after the stipulated period was solely due to non-payment of the respondent, for which the respondent cannot suffer. The clause 4. Sorry, my lord, that would be petitioner cannot suffer. The clause 4.7 makes the refund subject to the certain conditions. Subclause A provides that if any defect or the defects of the work are detected after issuance of the completion certificate, the same are to be rectified to the satisfaction of the engineer in charge within the defect liability period of the 6 months or its due extension till completion of the rectification as required. In the present context, no such defect was even intimated to the petitioner and has been averred in the opposition and the respondent to entitle the respondent to insist upon the rectification of the same. So this was not there, this has not been argued, but my lord, the lordship was taken note of it. Since the contractual work done by the petitioner was of supplying the heavy machinery of the extracting coal, it cannot be come within the purview of the subclause B, which speaks about the building works and the other works of the similar nature. Subclause C also not applicable, since the work was not confined to the supply, installation, and the commissioning of the equipment of the electrical or the mechanical work. The supply of the heavy machinery and the transport of the coal and the extraction of the coal thus is not covered within the subclause B and C. Another aspect is required to be looked into. there is a rider in the clause 4.1 which defines the security deposit to the effect that the security deposit shall bear no interest. Since the petitioner also claim interest on their dues, a question may arise as to whether they are entitled to the same, although not specifically raised by the respondent. Such issue is also to be looked into at the same hilts at the very root of the petitioner entitlement to get interest. Such right at the clause 4.1 is to be read in the proper perspective, and the security is to be deposited at the inception of the work and refunded within the 6 months after the completion of the work. The reference to interest thus covers the period in between, since in the terms of the GTC contemplate the security deposit to be refunded with or without deduction within 6 months from the completion of the work. The contemplation of the clause must pertain to the such period only. Interest, if any, directed by the court for any fault on the part of the employer cannot be the subject matter of the terms of the GTC, and thus bar in clause 4.1 does not cover the such court awarded interest. The clause 4.7 mandates half of the security deposit to be repaid immediately. Regarding the other half, the respondent has to refund the same within the 6 months performance guarantee period from the date of the completion as certified. In the present case, if the security deposit was paid in time, no interest could be levied thereon, as per the Milord consonants of the contract. The rider in the clause 4.1, which are discussing, evidently indicates that the security deposit shall bear no interest from the date when it was deposited till the date it was refunded, which is a quite rational, keeping in view the fact that it is by the definition of the refundable security deposit. However, for withholding the such payment after the due date, after the due period, there cannot be any scope for the rider being operative. The entitlement of the petitioner to interest would be on the premise that if the amount was refunded in time, the same would have fetched interest at the existing bank rate. The clause 4.1 does not preclude interest being awarded to the petitioner by the court. In all fairness, the said argument has not been advanced by the respondent, but clause taken into consideration in order to lend finality of the closure to the issue. Since no deficiency or the defect of the work of the petitioner was informed to them within the 6 months performance guarantee period, there could not be any justifiable reason where, Milord, this arbitrariness has been answered. Initial point was taken in the, Milord, the initial, Milord, when the order was dictated, that, Milord, whether there is an arbitrariness, that has been, Milord, the response was given. There could not be any justifiable reason to withhold the security refund from the petitioner. The present consideration would be incomplete without dealing with the proposition advanced by the respondent that the cause of action of the respondent remains alive until the writ petition is disposed of. The said argument is entirely beside the point, since in the cited judgment, the merger of the cause of action principle was laid down on the premise of the cause of action of the suit itself. The said principle was not in the context of the defendant. It would be absurd to claim that the cause of action of the defendant can arise on the basis of the plaint. The respondent claim of rupees such and such on the alleged dues regarding the different contract was never made to the affidavit in opposition at all. Thus, there was no counter such and such, such and such. Then, Milord, the judgment of, Milord, the counter claim has been referred 46-47. Milord, kindly have a look at 48. Thus, in absence of any of the claim being made by the respondent during the 6-month performance guarantee period, the petitioner is entitled to refund of the entire amount of the security deposit. However, since the dispute has been raised by the respondent regarding the deposit of the additional performance security, the said component cannot be adjudicated within the scope of the writ petition, as has to be ascertained from the fact by taking evidence by both the sides. Also, the payment of the additional charges and the interest and the beyond the project, as enumerated in the chart annexed to the such and such of the writ petition, cannot be awarded without taking evidence. Which claim has been, Milord? Has not been, Milord, the allowed. Hence, the petitioner are entitled only to the amount of the security deposit and retention money which were admittedly deposited by the petitioner. Taking such component into the account on the basis of the chart annexed to the page 167, and the deducting the additional performance security of such and such, a sum due payable to the petitioner comes to such and such. However, in view of this is the concession given by us, when they have, my lord, intended to make out a case in their opposition, saying that I do have demand of 1,69 lakhs and odd figures, I come forward and say, on, my lord, instruction, saying that even if you deduct this amount also, although this amount did not raise during the period, to allay any dispute, to allay, my lord, whether there is any disputed claim or not. So, however, in view of the concession given by the petitioner in respect of the respondent claim 1,69 lakhs 10,607 in their affidavit in opposition, the said amount also to be deducted. So, it is on the basis of the concession given by us. Accordingly, the amount due payable to the petitioner is immediately 4 crore and odd figures minus such and such is 2 crore 96 lakhs and such and such. Then, my lord, the interest part has been mentioned in the paragraph 50 and 51. In support thereof, my lord, we have already submitted decisions. My lord, I want to rely upon few decisions, my lord. Thereafter, the last portion, my lord, I will place. My lord, kindly take trouble to, my lord, have a look at my compilation of the, my lord, the judgment. This is not that. My lord, 2023, my lord, SCC online SC 470, serial number 6 of my compilation, my lord, spiral binding document. Page 219. I am relying, my lord, the paragraph 27. This is on the principle that, my lord, subject to lordship's kind correction, that this is only the principle, my lord, where a clause can be interpreted in two ways. If the honorable trial court interpret in a particular manner, what would be the duty reposed upon the, my lord, the honorable division bench to look into the matter?
Discretion.
My lord. The paragraph 27, this is the recent decision, my lord. 27, it has been held by the court that the appellate court would not interfere with the exercise of the discretion of the court of the first instance and substitute his own discretion, except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court has ignored the settled principles of the law regulating the grant and the refusal of the interlocutory injunction. So, my lord, here, if your lordship hold that this is a rewriting of the contract, in that event, lordship is correct, my lord, to change the, my lord, the decision taken by the, my lord, the trial. If it is thing that, my lord, the interpretation can be done in both the ways, in that event, my lord, it is my respectful submission, my lord, to give honor to the, my lord, the interpretation given by the, my lord, the honorable trial court. My lord, next decision I intend to rely upon, that is 2007 SCC online Calcutta 264. This is, my lord, very common decision, and Supreme Court decisions are also there. If your lordship see in his entirety, few language would be there which against us, few language would be there in their favor also. The basic principle is this, my lord. Kindly have a look at page 227. Paragraph 31 and 32. So this maxim is pertaining to after coming the court, whether my position would be derogated or not. So, my lord, my right stands crystallized on the date of the institution of the suit or institution of the writ petition. Why I am saying so, my lord? My case is far better than this, my lord, analogy. But the fact remains, for an abandoned precaution, my lord, I am citing this decision. In paragraph 30 and 32, my lord, it has been stated In the case of the such and such, the Honorable Supreme Court and they rejected the contention that due to the event subsequent to the filing the petition, the application was no longer maintainable with the following words. The validity of the writ petition must be judged on the fact as they were at the time of the presentation. And the petition which was valid when presented cannot, in absence of the provision to the effect in the statute, cease to be maintainable by the reason of the event of the subsequent to its presentation. So assuming that I don't have any case, but subsequently they have disclosed that we do have a demand. They have failed to show that this demand did not arise on the relevant point of time. So whatever might be the case, if on the date, my lord, our writ petition was instituted on 24th of November 2023. That was adjudicated on, my lord, for the month of March 2024. Even if, my lord, there is any development which is in favor of the, my lord, the respondent, in that event also my position cannot be derogated. And, my lord, the change of the circumstances is not attributable to the petitioner. For an abandoned precaution, my case is far better than this, my lord. For an abandoned precaution, I am citing. Only on the principle where the writ court can award interest, it is, although, my lord, not a, my lord, the issue of res intriga, but Surya construction is a, my lord, very small decision. I am referring, that is page 235 to 236. My lord, paragraph 3, 236. It is clear, therefore, from the aforesaid order dated such and such that there is no dispute as to the amount that has to be paid to the appellant. Despite this, when the appellant knocked at the door of the High Court in the writ petition, being the writ petition number such and such, the impugned judgment dated such and such dismissed the writ petition stating that the disputed question of fact arises, that the amount due arises out of the contract. We are afraid that the High Court was wholly incorrect, inasmuch as there was no disputed question of fact. On the contrary, the amount payable to the appellant is wholly undisputed. Equally, it is well settled that where the state behaves arbitrarily, even in the realm of the contract, the High Court could interfere under Article 226 of the Constitution of India. This being the case, the work having been completed long back in 2009, and we direct the Uttar Pradesh such and such, make the necessary payment with the period of the 4 weeks from today. Given the long period of the delay, interest such and such may be awarded. The basic ratio is this: even the writ court can interfere and may impose interest to, my lord, to do the justice, because the injustice which has been meted to the, my lord, the writ petitioner, to undone this. So, my lord, the last paragraphs, few paragraphs, my lord, which has already been, my lord, stated. Paragraph 50, my lord, kindly have a look at page, my lord, 277 of the impugned order, my lord. The petitioner are also entitled to get the interest on the said sum at the rate of the 8% per annum till the repayment. Since it was the fault of the respondent that the amount was withheld for so long, in so far half of the amount is concerned, keeping in the tune of the clause 4.7 of the GTC, the interest shall be payable from the date of the completion of the work as certified, that is, from the November 2022. In so far as the balance half is concerned, as per the clause such and such, the respondent has 6 months, further months to repay the same. Thus, the entitlement of the petitioner to get such amount starts after the expiry of the 6 months thereafter, that is on and from May 30, 2023. So, in consonance with the judgment, my lord, that has been given, no relaxation was given, that the, my lord, in entirety that would be given on the first day. Accordingly, my lord, the observation has been made. So, my lord, so far is the performance guarantee is concerned.
How much more time you would require, Mr.
Just,
Datta?
my lord, only sum up, my lord, for 5-10 minutes, my lord. But today's I am having, my lord, difficulty. On March, my lord, we have to go. Just I will sum up, my lord, so that, my lord.
Probably 15 minutes you will.
My lord, sufficient.
Chaudhary will all want to say anything. Nothing.
But after they finish, my lord, we will reply in next state, my lord. Next state, my lord.
Are on that day, my lord, after completion, Mr. Chaudhary will argue and complete the matter.
There's one more date.
No, my lord, today, my lord, he just said that he has.
No, not the today, not today.
More about it. No
Then-
problem.
then-
He will
then
fix
it will
thereafter.
come tomorrow. No. Wednesday it will come.
My lord.
You have heard Mr. Subrata Dattal and Advocate appealing respondents number 1 and 2 for continuation of the submissions this day after tomorrow under the same caption.
Yes, sir.